USCIS just released fresh I-140 and adjustment processing data that changes how smart applicants should plan for 2026. If you're on F1, H-1B, O-1, L-1, or you're abroad preparing an employment green card case, you cannot rely on last year's assumptions. The numbers show where demand is moving, where approvals are tightening, and which categories are becoming crowded. In this video, I will translate the data into plain strategy. What it means for EB1, EB2 NIW, EB2 PERM, and EB3, and what actions reduce risk right now so you can choose the right path and avoid costly delays. Welcome to US Policy Brief. I'm Fernando. I do not sell shortcuts, and I will not promise approvals because USCIS decisions are discretionary and case-specific. This is general information, not legal advice. Always consult a qualified immigration attorney before filing, especially if you have status gaps, prior denials, criminal issues, or complex travel histories. Now, when I say new data, I mean the public USCIS reports on receipts, approvals, denials, and requests for evidence. Those reports do not predict your outcome, but they do reveal shifting pressure points, and they help you decide where to invest time and profile. For a decade, the default employment path looked simple: study on F1 work on OPT, win H-1B, then your employer files PERM and an I-140 in EB2 or EB3. For many countries that still works, but for high-demand countries, and now for some smaller countries in particular categories, the wait to actually receive a visa number can be long enough to change careers, families, and life plans. That reality pushed more people to explore self-sponsored options, especially EB1A and EB2 national interest. Waiver USCIS data shows that shift clearly, and it also shows where the new bottlenecks are forming. When people say EB1, they often mean three different things. EB1A is extraordinary ability and can be self-petitioned. EB1B is outstanding professor or researcher and requires an employer, usually a university or research institution. EB1C is multinational manager or executive and requires a qualifying company relationship. USCIS approval rates for EB1 overall can look strong, but the combined number can hide differences among these subcategories. In 2026, the trend is clear. More applicants are trying EB1A, so adjudicators are applying standards more strictly. That does not mean EB1A is impossible. It means your evidence package must be tighter and organized. EB2, NIW grew fast because it sounds simple. No PERM, no employer sponsorship, and a three-part test from the Danasar framework. But national interest is not a fixed checklist. USCIS officers evaluate whether your proposed endeavor has substantial merit and national importance, whether you are well positioned to advance it, and whether waiving the job offer benefits the United States. Those concepts can be applied inconsistently across officers, and over time new data suggests more RFEs and more denials in some quarters, which means many applicants must invest more in expert letters, evidence, and strategy than before to win approvals. So, what does the new USCIS data show for 2026? It shows employment-based demand shifting into categories that seem faster, while older categories remain clogged by visa number limits. I-140 receipts for EB1 have risen, NIW filings remain high, and PERM-based cases continue but face long downstream waits. In many situations, USCIS also reports a steady volume of requests for evidence in both EB1A and NIW, which tells us the agency is asking for tighter proof, clearer narratives, and stronger documentation of impact. The lesson is simple. Category choice is a strategy decision, not a default for most applicants today. One thing the data cannot show directly is visa bulletin timing, but you must connect the dots. USCIS can approve an I-140, yet you may still wait for a visa number based on your category and country of chargeability. Some applicants outside oversubscribed countries can move from I-140 to green card in under a year, especially with employer support and dates. Others may wait far longer even after approval. That is why the best category is not universal. Your strategy should account for your country, your family plans, your tolerance for travel limits, and your employer's willingness to keep sponsoring. If you are considering EB1A, remember the two-stage analysis. First, you must meet at least 3 of the 10 regulatory criteria or show comparable evidence. Second, USCIS performs a final merits determination, asking whether the totality proves sustained national or international acclaim, and that you are among the small percentage at the top of your field. That second step is where many weak petitions fail, even if they technically check 3 boxes. So build depth, not just quantity. Evidence should show impact, leadership originality, and recognition from independent sources, not only internal company praise or paid memberships and weak citations. Strong EB-1A cases usually tell a coherent story. You made original contributions. They influenced others, and independent institutions recognize that influence. For researchers, that can be publications, citations, peer review, grants, and invitations. For entrepreneurs, it can be revenue, job creation, patents, media coverage, and market adoption. For artists, it can be leading roles, critical reviews, awards, and prestigious venues. For engineers, it can be standards, work inventions, and evidence that your work is used widely. The key is third-party validation. USCIS is skeptical of self-written letters and employer-only praise, so aim for independent evidence wherever possible from credible sources. If you are an academic or corporate manager, do not ignore EB-1B and EB-1C. They are not self-petitions, but they can be more predictable when you fit the definitions. EB-1B requires international recognition and a qualifying offer for a tenured tenure track or comparable research position. EB-1C requires 1 year of managerial or executive employment abroad and a qualifying relationship between the foreign and U.S. entities. Many online discussions lump these into EB-1 success rates, which can make EB-1A seem easier than it is. For viewers, the lesson is to compare the right subcategory to your role, not the headline number. For EB-2, NIW, treat the petition like a persuasive brief, not a resume dump. Describe your endeavor so a non-expert officer can understand it and connect it to national importance beyond your personal success. Strong NIWs succeed by proving scale measurable outcomes, adoption, and a U.S. plan. Letters should be specific and independent, explaining why your work matters and why you are positioned to advance it. Trends show more RFEs on prong 2 and prong 3, so address those directly with documents, not only statements. If you are building a startup, show traction, customers, and impact, not just intent today. Now, EB2 and EB3 through PERM are not dead, even if online talk makes them sound useless. They remain the standard path for many workers, and employers still sponsor when the role is critical. The challenge is timing. PERM recruitment audits and processing can be slow, and the visa bulletin can add years for certain chargeability groups. But for many countries, EB2 and EB3 remain workable, especially with premium processing on the I-140 and stable employers. The strategic question is whether you can tolerate the full timeline while maintaining status, or whether a parallel self-petition is worth the additional effort. Be careful when you see marketing that says approval rates are rising. USCIS publishes approval rates by form and category, but those numbers do not reveal the quality of filings behind them. A higher rate could reflect better prepared petitions, or it could reflect a surge in employer-sponsored subcategories that are easier to document. For self-petitions, the question is not the average, but whether your evidence meets the standard and whether your narrative survives officer review. If someone promises 90% success without reviewing your documents, treat that as a warning sign. Real preparation includes hard feedback, not only optimism today. What can you do with this data? Start by controlling what you can control: speed of preparation, quality of evidence, and procedural choices. If you are eligible for premium processing on your I-140, consider whether the faster decision helps your overall plan, especially if you need an EAD or travel document through adjustment. If you are filing adjustment of status, track the medical exam rules, your priority date, and your I-485 filing window. Build an RFE-ready packet from day one. Clear exhibits, citations, translation certificates, and a strong cover letter that ties each piece of evidence to the legal elements. Because you asked for an all-countries view, here is a planning principle that applies everywhere. Do not confuse USCIS approval with visa availability. If your category is current, a faster I-140 can lead to a faster green card. If it is not current, you are building a place in line. Consider strategies like cross-chargeability through a spouse's country when permitted, but do it with legal guidance. Also compare consular processing versus adjustment of status. Because travel flexibility and timelines differ, USCIS data shows processing trends, but the State Department controls visa numbers and interviews, so your timeline depends on systems. USCIS RFE patterns match what many attorneys see. The biggest error is not lack of talent, it is lack of explanation. Applicants upload awards without explaining why they matter, cite media without showing reach or list memberships that are not selective. In NIW cases, people describe a job title, but not an endeavor, or they claim national importance without evidence beyond opinion letters. In 2026, officers want measurable proof. Independent coverage, adoption metrics, contracts, patents, citations, and clear U.S. plans. If you cannot explain your evidence in simple terms, the officer will not infer the meaning for you at all. The practical implication of rising EB-1A interest is competition. When more people file, USCIS has more cases to review, and standards feel stricter because borderline petitions are denied more often. That does not mean you should rush a weak case. It means you should either strengthen your profile before filing or choose a category that matches your evidence today. If you are early in your career, you might build publications, leadership roles, speaking invitations, and independent coverage before you file. If you are already established, move efficiently. Timing matters for filings, and keep your evidence current as you plan ahead. A second implication is visa bulletin pressure. As EB-1 demand rises, more countries may see retrogression in final action dates, especially if worldwide demand consumes unused numbers earlier in the fiscal year. Even if your country has historically been current, it can become temporarily backlogged when demand spikes. That is why you should watch the visa bulletin regularly. When dates are current, adjustment filing windows can open and close quickly. If you are eligible to file, missing a window can cost months. If you are not eligible, prepare your petition so you are ready when the line moves again soon. You also asked why so many people feel employers are sponsoring less. In some industries, layoffs, compliance costs, and long timelines make employers hesitant to commit to green card programs. H-1B itself can feel less stable when companies reorganize and workers change roles. That is why self-petition categories are attractive. They reduce dependence on one employer. But self-petitioning does not remove the need for strong evidence, and it does not erase visa bulletin constraints. An approach is parallel planning. Continue employer sponsorship if available, while evaluating a NIW or EB-1A if your profile supports it. Parallel planning can reduce risk. Here are quick self-check questions that match the USCIS criteria. For EB-1A, can you prove awards with known selection standards, memberships that require outstanding achievement, published material about you, judging work, original contributions with documented impact, scholarly authorship, leading roles, high compensation, and commercial success, if relevant? For NIW, can you define an endeavor with national importance, show you are well-positioned through education and record, and show that waiving perm benefits the U.S. more than the labor test? If your answer is maybe, you may need profile building. If it is yes with evidence, you may file this year. Next, understand the pipeline timing. The I-140 is the petition stage where USCIS evaluates eligibility for a category. The green card stage is adjustment of status inside the U.S. or consular processing abroad. A faster I-140 does not always produce a faster green card if visa numbers are unavailable. But it can still help because it locks in a priority date and can support extensions in some work visa contexts. In 2026, processing times vary by service center and category, so track where your petition will be adjudicated and plan for RFE cycles. Build your timeline with buffers, not assumptions. A strong petition is not only about achievements, it is about packaging. USCIS officers read fast and follow checklists. Use a table of contents, label exhibits, and connect each exhibit to a criterion with a short explanation. For EB-1A, focus on a few strong awards and prove selection standards. For NIW, use letters that explain the endeavor, the national need, and your unique position with specifics. Add objective metrics, citations, revenues, contracts, grants, adoption numbers, press reach, patents, or standards. The more you make the officer's job easy, the better your odds in a stricter year for case in 2026. One caution: do not manufacture evidence. USCIS is trained to detect templated recommendation letters, suspicious citations, paid press placements, and exaggerated claims. The moment credibility is lost, approval becomes unlikely, and future filings can be harmed. Use truthful accomplishments and explain them well. If you are building your profile, do it the real way. Publish quality work, speak at legitimate conferences, mentor teams, file patents based on actual inventions, and pursue awards. You legitimately qualify for a slower, honest build is safer than a fast, artificial build. The data shift in 2026 makes scrutiny higher, which makes credibility more valuable. If you want to follow the trend yourself, use official sources. USCIS posts quarterly and annual reports with I-140 receipts, approvals, denials, and processing ranges. Combine that with the Department of State Visa Bulletin and consular wait time pages. When you see someone quote a chart, ask for the original link and confirm what is being measured. Approval rate on I-140 does not tell you how long until a visa number is available. Data is useful only when interpreted across the whole pipeline, from petition to visa availability to final green card issuance, so you can spot noise and plan. Do not treat EB-1A as the only escape. For many applicants, O-1 can be a bridge while building evidence. For some, an employer-sponsored EB-2 or EB-3 with a stable company is still the most predictable route. For others, NIW fits better than EB-1A because the endeavor is strong even if a claim is still growing. The best approach is a portfolio mindset. Choose the category that matches your strongest evidence now, then keep building options. USCIS data is showing divergence, not one winner. Your goal is not to chase what is trending online. Choose a pathway you can sustain long-term. Here is what to do in the next 30 days. 1. Download the latest USCIS I-140 quarterly report and note the direction of receipts and denials in your category. 2. Evaluate whether your evidence fits EB-1A or NIW without stretching the truth. 3. If you are in EB-2 or EB-3, PERM, speak with your employer about timing and whether they will support you through the whole process. 4. Build a document folder. Now publications, letters, contracts, media awards, criteria, and proof of impact. 5. Decide whether premium processing makes sense. 6. Watch the visa bulletin and be ready to file. Please do not post private case numbers publicly, but you can ask general questions in the comments. Use this video to ask smarter questions of your attorney or employer, because no video can replace a document review. Eligibility depends on your exact evidence, your immigration history, and visa bulletin timing. Still, trends help you decide where to invest effort. In 2026, USCIS data suggests self-petition categories are more popular, and popular categories become more competitive. Preparation is your advantage. If this helped, subscribe to US Policy Brief and turn on notifications so you do not miss the next data update. Let me summarize the shift in one sentence. In 2026, more people are moving toward EB-1 and NIW, and USCIS is responding with more scrutiny and RFEs, so you must file smarter, not just faster. EB-1A is powerful when you can prove sustained acclaim and impact. NIW is powerful when you can prove national importance and a plan. PERM, EB-2, and EB-3 still work when timelines and employers align. Use USCIS reports as a compass, not a promise. Build evidence, organize the story, and watch the visa bulletin. That combination protects your future in the U.S. immigration system in 2026. If you want me to cover a specific category, next comment with your current status and goal, like F1 to H1B, O1 to EB1A, or employer PERM to EB3, and I will build a focused episode. If you found this useful, subscribe to US Policy Brief so you receive the next USCIS data breakdown as soon as it drops. Share this video with a friend who is stuck in the backlog and thinking of switching categories, because the biggest mistake is moving without understanding the data. I'm Fernando, and I'll see you in the next update. Thanks for watching today. One last tactical tip. Plan for the RFE before it arrives. USCIS often asks for the same missing pieces, so pre-write your explanations and keep backups. For EB-1A, maintain evidence of award criteria, circulation numbers for publications, and proof that judging invitations were selective. For NIW, maintain a one-page endeavor summary, a list of U.S. stakeholders, and documentation of outcomes like pilot programs, letters of intent, or deployments. If an RFE comes, respond fast but calmly, addressing every point with exhibits and citations. A rushed, emotional reply can harm a strong case. An organized reply can save it for you.